Hi, everyone. My name is Rachel Marks, and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Kevin Estevez, an Arizona construction lien law guru. Today's webinar's topic is, what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Kevin Estevez.
Thank you, Rachel. Good morning, everybody. My name is Kevin Estevez, like Rachel said, and I'm going to be talking to you today about what happens after I record my lien and how do I get paid. And with that, let's jump right in. If you have any questions during the course of the webinar, please use the chat box on the right-hand side of your screen, and we will answer any questions at the end. Please don't include company names or your names in the questions, and we'll get to them. So the first topic is a little bit of a recap. How do you preserve your mechanics lien rights in Arizona? And we've done these presentations before, and we've addressed these most recently a couple months ago. But before we jump into what happens after you record your lien, let's just do a refresher on the steps you need to take to record that lien and preserve your lien rights. So the first step is to timely serve a proper preliminary 20-day notice. In Arizona, except for laborers for wages, every mechanics lien claimant must serve a preliminary 20-day notice. So if you take one thing away from today's presentation, please take that away. It is extremely important in Arizona to serve a preliminary 20-day notice. If you don't serve a 20-day notice, you forfeit all your lien rights. If you don't serve a timely 20-day notice, you forfeit a portion of your lien rights. The way preliminary 20-day notices work in Arizona is they catch back 20 days and recover and cover all the work or materials provided from that point going forward. So say you start work on May 1st and you don't serve a 20-day notice until May 30th. What happens is if that 20-day notice is served on May 30th, it reaches back 20 days and you would have lien rights provided that the notice is effective and the amounts are correct and so on and so forth. But you'd have lien rights from May 10th going forward. But you wouldn't have lien rights from May 1st to May 10th. So any labor and materials furnished in that time would not be protected by mechanics lien rights. So it's important that you serve your 20-day notices timely. You want to serve it right when you start work or furnish materials to a project. But at the very latest, you don't want to wait until 20 days after furnishing materials or providing labor to a project. Second step on this slide here, to preserve your lien rights. Don't forfeit lien rights by signing an improper and incorrect lien waiver. You see this happen sometimes, and this is going to be the topic, I believe, our next presentation in a couple months. You need to be careful with lien waivers. Arizona has 4 statutory forms that are used. You have a conditional progress, a conditional final, a conditional progress, a unconditional progress, a conditional final, and an unconditional final. You need to pay specific attention to what forms are appropriate in the right circumstances, and make sure you're not signing an incorrect waiver before you've received payment and that payment has cleared. And like I said, that's something that we'll talk about next time. And so the final step is to timely record a statutorily compliant notice and claim of lien with the county recorder in the county where the project is located. The required contents of notices and claims of lien, which is a subject we've covered on these webinars before, in Arizona is located in ARS 33993A. The time to record a notice and claim of lien is measured from 120 days of completion of the project in most instances, or if a notice of completion is recorded and served within 60 days of that recording of that notice of completion. What completion means for the purposes of the 120-day time frame to record your notice of claim and lien can vary based on the type of project at issue. So if a certificate of occupancy is issued, completion is 30 days after the C of O. So you have technically 150 days from the issuance of that CO to record your notice and claim a lien. If no CO is issued, completion is the last day labor or materials are furnished to the project. And then finally, if work is stopped, completion is 60 days after cessation of labor. So in that last instance, you'd have 180 days after the cessation of labor to record your mechanics liens. So that's a little bit of a recap on how to preserve your lien rights in Arizona. And with that, let's move over to, you've got your lien recorded, you've taken steps not to waive your lien rights, and then what happens next? So after your lien's recorded, the first thing you need to do is timely serve the notice of claim and lien. Then you need to be on the lookout for lien discharge bonds. Then you must sue to foreclose the lien within 6 months of recording. And finally, a notice of lis pendens must be recorded within 5 days of filing suit. So that's a general overarching discussion, 30,000-foot view of the topics we're going to be diving into in more detail, and we'll address each one going forward here. So first thing you need to do is serve a notice and claim of lien pursuant to ARS 33-993A. Lien claimants are obligated to serve copies of their notices and claim of liens on property owners within a reasonable time of recording. The term serve requires that service be made it can be made by mail, but it needs to be first class registered or certified mail, with the sender obtaining a certificate of mailing, receipt of registration, or receipt of certification. Also, you can serve a notice and claim a lien on the owner in the same manner that process is served. And usually that's by a process server. So you see that done in some instances, but mailing it with the above conditions and under the above terms would suffice for service too. The phrase "a reasonable time after recording" is not defined by Arizona law. Nevertheless, the notice of claim and lien should be served promptly. And there is, while the term "a reasonable time after recording" is not defined, there is an Arizona Court of Appeals decision that's held that absent unusual circumstance, the notice requirement of 33-993A will not be met by merely appending a copy of the notice of claim of lien to the complaint filed in the action to foreclose that very lien. So you want to do it before you want to serve the lien before you sue to foreclose on the lien. And in most foreclosure cases, it's proper to attach the lien to the complaint, but you want to have it served before you attach the complaint, file the lawsuit, and serve the lawsuit. So once you get your notice of claim and lien recorded and served, how do you get paid after that? Well, typically, once that happens, you can get an owner's attention, and cases will typically be resolved through negotiation at that point. If negotiations prove unsuccessful, or if an owner or contractor at that point are unwilling to engage in negotiation, you got to sue to foreclose. Before we get to that, one thing to be mindful of in Arizona, after you serve your notice of claim and lien, notice and claim of lien, is the potential for a property owner to record a statutory discharge of lien bond. And these bonds are governed by ARS 33-1004. And generally speaking, they must be recorded in the county where the project is located and served on the lien holder. And what these do is they discharge the lien on the property, and the bond is there in place to allow the lien claimant to pursue the bond, where the party that posts the bond will be the principal, will be a surety who will be the surety under the bond, and then the lien claimant will be the obligee under the bond. And so that bond is there. It'll be 1.5 per statutory requirements, 1.5 times the amount of the lien, and it'll be there. And then what happens is when a lawsuit is already pending, the lien claimant amends the lawsuit to remove the claim against the lien foreclosure claim against the property, and then assert a claim against the bond. And if a lawsuit is not pending, the lien claimant must file suit against the bond within 6 months of recording its notice of claim and lien. So the time frame doesn't vary. You still have the 6 month with 6 months within which to sue to foreclose, or in this case, sue on the bond that you would have to sue on the lien foreclosure lawsuit had the bond not been filed. Okay, with that, let's talk about the notice, the mechanics of a lien foreclosure lawsuit in Arizona. What a lien foreclosure lawsuit does is it asks the court to order the sale of the property to satisfy the liens. Mechanics lien claimants are required to prove the validity of their lien and the value of the materials or services provided. Like I said before, the lien foreclosure action must be filed within 6 months of the recording of the lien. If no foreclosure action is filed within that time frame, then the lien expires by operation of law and is no good. And in certain circumstances, provided work is not complete on the project, a lien claimant may be able to re-record, but that lien that they required and did not foreclose upon, that would have expired as a matter of law. The necessary parties to a foreclosure lawsuit in Arizona are all others holding an equal or inferior interest in the property. So that would be all other parties that have recorded liens on the project. And typically, in order to make sure that all the right parties are named, lien claimants will obtain a litigation guarantee from a title company, which identifies all those claiming an equal interest in the property and that need to be named. One thing to note, and this will be something that will be handled by the attorney handling the foreclosure lawsuit, but you need to be careful with lenders. Sometimes, often, but not always, lenders have a superior interest in the property to lien claimants. That depends on when work was started on the project, vis-a-vis when the lenders recorded their deed of trust, and that's a more complex issue. But that's just something to be mindful of in the whole environment of a lien foreclosure lawsuit. Typically, there's going to be a lender involved, and you need to be mindful of whether or not you have superior rights to the lender or inferior rights, and that dictates how they're addressed in the lien foreclosure lawsuit. What happens is claimants with valid mechanics liens will share the proceeds of the sale of the property pro rata if it goes that far, and that the lien foreclosure or the lien statutes in Arizona, allow the courts to award the successful party its reasonable attorney's fees. Just as an aside, and this is something that will also be handled by the attorney that handles the foreclosure lawsuit, but you have to record a lis pendens within 5 days of filing suit. If you fail to do that, the lien is no longer valid. A lis pendens is a notice of pendency of action that is designed to provide a general notice that a lawsuit is pending that affects title to the subject property. And pursuant to ARS 12-1191A, a lis pendens shall contain the names of the parties, number 1, number 2, the object of the action, number 3, the relief demanded, and number 4, a description of the affected property. The last topic we're gonna talk about today is recording a release of lien. We'll just touch on this briefly. So assume that you go forward, you record your lien, and after the lien is recorded, you either negotiate a settlement with the parties upstream, either the owner of the property or, in the case if you're a subcontractor or supplier, a general contractor or potentially a subcontractor, and you get paid, or you sue to foreclose, and that foreclosure lawsuit leads to a judgment, and the property is sold, and you receive payment. In that instance, what you need to do next as a lien claimant is you need to record a release of lien within 20 days after satisfaction. So, and that's covered by ARS 33-1006A. And failure to provide such a release subjects the lien claimant to liability in the amount of $1,000 and also to liability for actual damages. So once you get paid, once you've gone through this process, you've perfected your lien rights, you've recorded your lien, and then either through foreclosure proceedings or just through negotiation before you get to foreclosure proceedings, once you get paid, you got to release your lien and essentially clear title to the property. So that is the extent of our discussion today. We have a disclaimer here. Arizona statutes and case law relating to construction industry are full of detailed technical requirements and exceptions. This presentation cannot substitute for specific legal advice. So to the extent you have questions or concerns relating to a mechanics lien or any other construction law issue, please consult a qualified attorney. And with that, I'll turn it back over to Rachel, and I'm prepared to answer any questions that any folks may have.
Thank you so much, Kevin, for your time today and educating us on these very important topics for Arizona. You provided us with super helpful and extremely valuable information. So right now, I don't see any questions that have come through. However, if anyone here does think of a question after the webinar, please feel free to reach out to myself or Kevin, and we will make sure to answer any questions you may have. Now, if you'll do me a favor and go to the next slide. Okay, if you'd like to take a moment to review us on Google, we would appreciate that. If you go to the next slide, Kevin. Okay, so I wanted to go over the next 2 upcoming webinars we have with Kevin. So the next one will be on Tuesday, August 22nd from 12 to 12:20 Eastern Standard Time, and the topic is lien releases. Be careful with what you sign. And then the next one will be on October 24th. From 12 to 12:20 Eastern Standard Time. The topic is getting paid faster with liens, bonds, and contracts. So go ahead and feel free to register at sunraynotice.com/education. And if you'll go to the next slide. So that's everything we have for you today. I hope that everyone has a sunny day, and we hope to see you on our next webinar. Thanks again so much, Kevin.
Thank you, Rachel. Appreciate it.
Have a good one, everyone. Bye-bye.